Well, good afternoon, everybody. Thank you very much for attending this briefing, which I hope will be valuable and clarify some of the questions and queries which have been transmitted to my chambers. And with me, Justice Garling, who's the chairman of the Court's Technology Committee, and also Rebel Kanar, the Principal Registrar, who does a huge amount of work around the court, not just in the registry, but in the formulation of rules and practice. So thank you for attending, and thank you for those who sent in questions. I'm going to try and deal with or integrate responses to questions in what I say. There'll be some scope for further questions at the end, but we did receive about 30 separate questions, or in some cases comments, in some cases kind, in some cases critical, in some cases critical but polite, in some cases critical, and I won't comment on the tone. In the event, I'll try and answer them, and as I say, we'll be open to further questions at the end. Meg will, when I'm referring to particular paragraphs of the practice note, put them up on the screen to assist. I'm not going to be reading it out. So, I mean, the obvious starting point is the importance of this topic and the sort of radical impact that Gen AI potentially has on what we do from day to day. It carries with it many advantages, but and benefits, but it also, at this stage at least of its maturity, carries with it some real risks and limitations. The legal profession is and always has been a critical thinking profession and subject to important ethical constraints and obligations in relation to how information and evidence is presented to courts and deployed in the administration of justice. So any regulation of Gen AI must bear those matters uppermost in mind. Qualified lawyers are admitted to practice law and are ultimately regulated by the Supreme Court. They remain responsible in relation to how they practice, and that responsibility is not delegable to a computer program, however sophisticated. That, I think, is a point of cardinal importance. People can get excited by the technology, be impressed by the technology, but it is not a substitute for people who are given the title of a lawyer, who are admitted to practice, bringing their own independent mind to what they do and bringing their own moral commitment to continue to abide by the undertakings they make when they are admitted to practice. Now, some of the limitations as currently understood, at least with some generative AI programs, are set out in paragraph 7 of the practice note. Many of you here who are obviously interested in the subject will be aware of them. There's the so-called hallucination, the generation of apparently plausible, authoritative and coherent responses to questions, and the production of apparently reputable case references and citations which turn out on examination not to be reliable or accurate, and in many cases not even close. The dependence of generative AI, at least in open sourced or publicly available programs, on the quality and reach of the underlying data set I mean, that applies to open and closed Gen AI programs, but of course the closed ones have the advantage of their proprietors having control over what goes in. There's much been written on the scope for biased or inaccurate output, again, a function of the underlying data sets. The fifth of the matters, the lack of adequate safeguards to preserve the confidentiality, privacy, or legal professional privilege that may attach to information or otherwise sensitive material. Now, that limitation has attracted a great deal of commentary from people who've responded to my chambers about the practice note, and it's been pointed out that those security concerns about integrity, protection of data which is put into a model, etc., will differ between whether a program is open sourced or closed sourced, and even within closed source may vary depending on the quality of the security and data protections the particular program offers. And there's a lot of competition amongst providers to emphasise the quality of their security settings to prevent data escaping or being externally accessed, or equally to prevent the data sets being polluted or impaired in some way. And I'll return to that. That has implications for particularly what's paragraph 9 of the practice note, which I'll return to. Without going to them, in the judicial guidelines, which is really a mirror document, there's a paragraph 11 which sets out what I've referred to and others have referred to as red flags, things for judges to look out for, and indeed for practitioners to look out for when dealing with documents that may have had some input by Gen AI. One Silk sent me a copy of a simple inquiry he'd made about the phrase "under an enactment" associated with search warrants. The response referred to some 5 cases, none of which existed or bore the correct citations, and to the extent that any case names represented a real case, that case dealt with an entirely different topic to that which was the subject of the inquiry. Now, whether or not that's a teething problem remains to be seen, but on any view it's an entirely unsatisfactory outcome and a salutary example of a major imperfection in at least some Gen AI programs. Obviously, it's important one has to avoid overgeneralising. There's a range of quality in terms of what is available. There are obviously highly responsible, sophisticated developers who are working on this area. There are others who just see a business opportunity, and that's what may be motivating them. So just to turn to some and answering some fairly basic questions which have been asked, that the practice note will commence in the first day of law term next year, which is the 3rd of February. It doesn't operate retrospectively, subject perhaps only to paragraph 25, which you can see up there, providing that expert reports prepared between the date of issue of the practice note and the date of its commencement must identify which, if any, parts of the expert report has or have relied on Gen AI in the preparation of its content. So there are 2 key documents. There's the practice note, SC General 23, and there's the guidelines for judicial officers. Both documents are published on the Supreme Court website under the heading Generative AI, and the same page on the website also contains copies of, or links to copies of, the Bar Association and the Law Society's guidelines. together with various practice notes and guidelines which have been issued by other jurisdictions, including New Zealand, the UK, Singapore, Queensland, and Victoria. The Queensland guidelines are expressly only directed to responsible use of Gen AI by non-lawyers, although there's some general information in them. Our practice note is directed both to lawyers and unrepresented parties. And in some respects, the use of Gen AI subject to the practice note may actually improve at least the clarity of what is sometimes presented by unrepresented lawyers in terms of formulation of argument. We'll wait and see. Somebody asked us where our power to issue this practice note comes from. Well, the court, there are many sources of power, including under the Supreme Court Act and the Civil Procedure Act, and indeed in the court's inherent jurisdiction to control its processes. The practice note is a Supreme Court practice note, so it only applies to proceedings in the Supreme Court, although I would expect that it will be adopted, perhaps subject to certain modifications, by other courts within the state. It's been drafted in collaboration with other heads of jurisdiction. The Land and Environment Court, for example, has already issued its own practice note, which is subject to, I think, one minor modification appropriate to that court, and I think perhaps stand to be correct, but I think in relation to commissioners, subject to that, it replicates the Supreme Court practice note. The guidelines for judicial officers are more general in terms of their application, but they are just guidelines. They don't, in terms, apply to NCAT matters or matters within the jurisdiction of the Personal Injuries Commission, although it would be open to the presidents of both of those bodies to adopt the judicial guidelines for their members. People have asked how the practice note was developed. These were, in a sense, the steps. There's been a detailed review undertaken of approaches taken in the other jurisdictions, the other common law jurisdictions, which have introduced practice notes or guidelines. New Zealand was the first jurisdiction to do so. The UK followed closely and drew very closely on the New Zealand guidelines, and the Victorian ones similarly derivative, I think, without intending any disrespect, of the original New Zealand guidelines. Singapore issued their practice note, I think, only 6 or 7 weeks ago. Singapore, as a jurisdiction, is heavily engaged with exploring the use of Gen AI in its court system. They have extremely well-resourced jurisdiction, and the Supreme Court has on its roster, as it were, technology experts who are exploring the potential use of Gen AI for low-level disputes, traffic accidents and fines and the like. So Singapore is a jurisdiction which is heavily engaged in Gen AI. On their practice note, I was waiting to see how they would go. They haven't followed the New Zealand model, which is largely cautionary, pointing out limitations in Gen AI. They've been a little more prescriptive, but it was a valuable source of information. Part of that review has also involved me having quite extensive discussions with Justice David Goddard from New Zealand, who was at the forefront of regulation, with Sir Geoffrey Voss, the Master of the Rolls in the UK, who was actually a strong embracer of the potential for Gen AI, and also with Chief Justice Menon of Singapore. the topic of AI and its use in the courts has been the subject of many judicial conferences and broader legal conferences over the last 12 months, a number of which I've attended and participated in. The practice note was developed in consultation with the Court's Technology Committee, with heads of the divisions and the President of the Court of Appeal, and with heads of other jurisdictions within New South Wales. We also had great assistance from the Law Society and the Bar Association. The Law Society, as many of you know, established a task force, and both the Law Society and the Bar had issued their own guidelines early last year, or was it early this year? Late last year, early this year, and that, in a sense, set some, or at least gave some guidance. And we've worked very closely with the Law Society and the Bar Association, including in an iterative way. So various drafts of the practice note went back and forth, and we received extremely useful commentary. There was also consultation of Supreme Court judges and some senior judges in the District Court and in the Land and Environment Court. So that's how it came about. I know we didn't have a broader public consultation, but in some respects, as will emerge, this exercise, which was a suggestion of the Law Society, actually a briefing of this kind, has been very valuable, as I'll indicate. So our practice note takes a more conservative approach than in other jurisdictions, but it's nuanced insofar as it differentiates between the use of generative AI to generate the content of primary witness and documentary evidence, the use of Gen AI by experts, and the use of Gen AI in written submissions and summaries of argument, etc., before the court. So it's not a blanket prohibition, but no other jurisdiction, I think, has gone so far or has been so explicit in proscribing its use in the generation of the content of evidence. And that was a considered decision on our part. Both the practice note and the guidelines recognise that this is a rapidly moving area, both in terms of technology and in terms of the commercially available products. In this context, there's much competition from potential providers to secure business. Their priority and their interest in securing the business of their clients doesn't coincide with the court's priority, although the court is obviously interested in and supportive of technology which saves costs, but without compromising important aspects of our system. And so in such a context of rapid development, it's prudent, I think, to be cautious and conservative in the approach we take in the regulation of Gen AI as it involves the courts. We have to, though, be vigilant about ensuring the integrity of outcome and not compromising court orders which are made for important purposes, including those in relation to confidentiality, privacy, and acceptable use of material which is compulsorily produced or required by the courts to be compulsorily reduced. That is an invasion, in a sense, of an individual or a corporation's property, requiring it to be produced for discovery or on subpoena, etc. And it needs to be, that intrusion needs to be respected, as it always has been, by doctrines such as the Harman undertaking and confidentiality orders, redactions to protect people and their reputation or their vulnerability, etc., in various ways I'm sure you're all aware of. Now, both the practice note and the guidelines also make clear that they'll be subject to periodic review to reflect growing experience and further technological developments. So the starkest feature, the blanket prohibition on the use of generative AI to generate content or to embellish the expression of a witness's evidence, that's made clear in paragraphs 10 to 15 of the practice note. It's driven by a very basic view that the evidence has to be the evidence of the witness, or the document can't have been created for the purposes of providing evidence in the proceedings. These are not particularly radical thoughts, but we know that Gen AI can do just that. It can produce witness statements, and it can produce witness statements which have a coherence and plausibility about them, which are drafted in an apparently impressive, fluent, articulate way. But that, of course, is not the witness's evidence. Now, I, of all people, am aware of the debate about how affidavits are prepared and the role solicitors play in assisting in the drafting of evidence, but we have to proceed on the basis, and with some exceptions, which are often brought out in cross-examination, we do proceed on the basis that the evidence which is presented in the form of a witness statement or an affidavit evidence is the genuine evidence of the witness. Of course, after cross-examination, we don't always proceed on that basis, but we must insist, we must proceed on the basis that evidence which is presented to us in affidavit or witness statement form is that derives from its content derives from the witness, not something else. Paragraph 12 is also important. Gen AI must not be used for the purposes of altering, embellishing, strengthening, diluting, or otherwise rephrasing a witness's evidence when expressed in written form. Gen AI has the capability to do all of those things. As many of you know who've played around with it, explored with it, you can ask it to express a proposition more simply, to express a proposition in the style of somebody else. I know one federal court judge submitted a paragraph and asked it to be expressed in the style of former Chief Justice Alsop, and it did, and it was different to the style in which the original draft was submitted. We've also introduced a disclosure requirement, as to say, a negative disclosure requirement that generative AI has not been used in any of the proscribed ways. Again, that was a very deliberate decision. Failure to provide such a disclosure may well influence the judge's willingness to admit the evidence, and a breach of the disclosure, namely exposure of the fact that the affidavit or witness statement the content has indeed been generated, will expose its maker and potentially a lawyer knowledgeable of that breach to contempt of court. So that disclosure is designed to play an important role. The same goes to the use of Gen AI to produce annexures or exhibits to affidavits. It doesn't expose a maker who is annexing a document which has come to his or her attention in the course of a business, for example, to guarantee that that document hasn't been generated by or produced by Gen AI. So it's nuanced in that sense, but except with the leave of the court, an exhibit or an affidavit can't be generated for the purposes of the proceedings by Gen AI. An example might be some sort of summary document, etc., and the practice note makes provision through the ability to seek leave in exceptional cases. But the rationale is the same as the content of the affidavit, similarly the content of exhibits. Of the various comments and questions we received, very, very few related to that aspect of the practice note. In other words, which I think is good. In a sense, Gen AI is a very sophisticated way, or offers the opportunity to fraudsters of forging documents. We've always dealt with forged documents in litigation, but the power to create so-called deep fakes, the more sophisticated ability to create false emails, false financial or accounting records which have a verisimilitude to them, and the sophistication of the computing power which allows that to be done means that we just have to be more vigilant than ever. There will be forms of disclosure for affidavits, etc., in the rules. The Rules Committee is meeting next week to settle some forms of disclosure which will be inserted into the rules and the various forms, and they've obviously been drafted consistently with the requirements of the practice note. The only further point of clarification about paragraph 10, this is responding to a particular question. There's a reference to cross-examination at the end, but it's not. The prohibition is on generating documents to be deployed as evidence following cross-examination. It's not a prescription of barristers or solicitors, if they wish to, using whatever use they want to make of Gen AI to assist in their preparation of cross-examination or and the like. So that I make clear. Turning to expert reports, again, we have taken a conservative approach, but again, I hope a nuanced one. The starting point is that an experts can give evidence because of their own knowledge, skill, and experience. That's a criteria of admissibility of an expert opinion. That's the law. And so we have to bear that in mind when experts want to use generative AI to produce conclusions or undertake analysis. That's the first point. The second point is that when you think back to Makita and Sproul's and other cases which govern the admissibility of expert evidence, an expert is required to disclose his or her reasoning process. That's a matter of basic procedural fairness. It allows the court to understand the steps in the reasoning process. It allows an opponent who wishes to test the conclusions to understand the steps by which the expert opinion was arrived at. And so generative AI, we know, has powerful computing. It draws on often large databases of information. I've read articles where people have been quite unable to explain how a particular result is produced, but seem happy with the outcome because they had a broad understanding, but they could not explain to you how the powerful algorithms work to produce the answer. So we have to be, I think, cautious about the use by experts of generative AI, but not so cautious as to proscribe it, absolutely. But we've introduced really two elements which are designed to address the problems I've spoken about. One is a requirement for leave if an expert is going to use Gen AI for the purpose of producing any of the content of his or her report, and the proposed use of Gen AI has to be A, disclosed, B, explained, the program which is to be used identified, and also some disclosure which deals with what I call the concerns about protection of privacy and integrity of compulsorily provided documents, which might be briefed to an expert if the expert is going to submit them to a model which doesn't have adequate security settings, etc., or where the data submitted to it may be available to the model for its ongoing learning or iterative growth of its database, which has potential ramifications for the security or limited use for which documents have been provided. That needs to be explained, but judges will grant leave if they're sufficiently satisfied of those matters and of the apparent benefit which will be derived from the use of Gen AI. And then, assuming leave has been given, the expert needs to make clear in the report where it's been used, how it's been used, if a particular outcome has been reached, a series of questions, etc. That paper trail, as it were, of interrogation of the program to produce the ultimate outcome needs to be preserved and documented so that the other side can understand what steps have been followed, can, in a sense, test forensically, as would happen usually in an expert report, can test and pressure test the outcome of the expert's report. Again, in the various questions which came through in response to the practice note, there were very few which related to experts. Written submissions, you've seen that we recognise that some practitioners will use Gen AI to assist in the development of written submissions. There's no proscription on that, but there is a very, very strong emphasis on the fact that you must take responsibility for any Gen AI produced summaries of argument or submission. I've already referred to the example of the hallucinations about the integrity. Some people have complained about the fact that we have said in the practice note that you can't use Gen AI to verify a Gen AI produced document, even if it's a different platform. Speaking for myself, I've been looking at this closely for well over 12 months, the problem of hallucinations has not been solved. It continues to be a problem, at least in certain open Gen AI models. I find it deeply concerning. I understand how predictive text works. I understand how interrogating a very, very large body of information with the assistance of algorithms, etc., can be valuable. I still am fundamentally confounded by the fact that completely false cases which have no basis in any decided case, with apparently plausible names, apparently plausible citations, can be spat out by generative AI programs. Similarly, with regard to legislation, an academic told me recently that she was marking an essay which referred to the Australian Consumer Protection Act, which she said was drawn from the legislation of Australia's 17 provinces. That was the opening sentence of a master's level essay. Well, it shows you. I mean, the universities are struggling with this, as many of you have followed, but we simply can't have inaccuracy and, dare I say, laziness enter the profession. It's not satisfactory, and it won't be tolerated by the Supreme Court. Judges are entitled to expect counsel and solicitor advocates to only present cases which are relevant and in fact exist. So we're making no apology for that, and I don't think anyone should think that we should. But it won't be satisfactory to say, "Oh, I relied on Gen AI," nor will it be satisfactory to say we relied on Gen AI to verify the submissions or the references in the submissions that we put. Again, I think that although some other practice notes issue cautions about that, we've decided to be more direct. Now, to come to the topic which has presented the most significant controversy and stream of questions, it relates to the fact that the practice note is stated to apply to open-sourced and closed-source large language model, Gen AI. That's paragraph 4. So, open source Gen AI has code which is open to the public or is able to be manipulated by the public. Generally, data input into public open programs will be publicly accessible, including to other large language models, and will be used to train the model. Every bit of information which is added to the model grows the database. That, apart from anything else, leads to the phenomenon of, quote, rubbish in, rubbish out. In other words, these models are only as valuable as the underlying data sets or data universes they contain. Open source Gen AI also presents serious concerns regarding security, confidentiality, and privacy. And that's one of the reasons why in the judicial guidelines, judges have been told not to submit draft judgments, even for proofing purposes, to Gen AI programs. The courts in New South Wales do not have bespoke Gen AI platform or any facility to even undertake that without risking the security of the draft documents. In relation to closed source AI and enterprise level AI is another phrase that really, these are typically bespoke Gen AI programs, proprietary programs, in the sense that they are capable of being developed and purchased from various providers and designed to have features which promote integrity in terms of the underlying data, and there's control over the data which comes in, and the proprietor of the program controls the knowledge which is there. And secondly, they're often typified by security controls. In other words, the users of the bespoke or closed source or enterprise level AI have an interest or various interests in ensuring the integrity and the protection of the data. And again, many of you will know that some firms and institutions have or are developing their own such, in a sense, private bespoke Gen AI programs or platforms. Now, that form of model doesn't address the underlying policy concerns which are reflected in those parts of the practice note concerned with using Gen AI produced content of evidence and expert reports. In other words, the same philosophical objections apply to the production of evidence, the production of content of evidence by such programs, at least as far as I'm concerned. And that's why the practice note applies to both open and closed source Gen AI. But where there is a material difference between open and closed source Gen AI is in the use of the latter, that's closed source Gen AI, as a powerful and beneficial means of document review and analysis. And people have written saying, well, there are various e-discovery platforms, for example, which have Gen AI components or functionality, which allows very large collections of documents to be scoured for the benefit of creating chronologies, document analysis, document summaries, etc. And so it's been put to me that the rationale or my concern about privacy, confidentiality, the integrity of orders of the court limiting the use of documents, etc., it's been put that that is not a concern with closed source AI. I accept that to a certain level. Let me explain. Depending on the size of the organisation, even a private platform will not necessarily, depending on the number of users of the platform, etc., and again, depending on the functionality, provide the sort of protections that one would hope for or expect. So if there was a closed source model which does allow the quarantining of the data so that it's only available for the purposes of the particular proceedings for which it's created, for example, and there is assurance as to, when I say assurance, I mean reasonable assurance from the product suppliers about privacy, ability to control confidentiality, and the like. As a matter of principle, there would be no objection to the use of such a platform or a model for intensive document review, creation of chronologies, and the like. Where it's not possible, however, within the closed programs to quarantine the information so that, for example, somebody with another client interrogating the closed system for information, maybe some commercial information, etc., it wouldn't be acceptable for that information to be available generally to that firm for all purposes. In other words, the data which is input shouldn't be permitted to in a sense, form part of and contribute to and augment the underlying database. Yes, the data is protected within that firm or that enterprise, but if it's available to be mined, as it were, by the technology for other clients or other purposes, then having a closed source system doesn't solve the concerns that I've expressed. But it may be, and I'm certainly open to persuasion about this, that may be that if the ability exists to ensure the integrity of the data for use only in the particular proceedings, that there are mechanisms in place to prevent it from being added to the underlying library of data, for example, and there are sufficient quality assurances there, then there can be no objection in principle to the use of Gen AI in that context. Not to generate content, but for doing the preparatory, the valuable, efficient reviews, etc., and not relieving people from responsibility for what they ultimately present. But I see it as subject to those safeguards, no different to what we currently have. A firm will have a database of documents, the other side's discovered documents, in big cases, all available digitally, able to be searched, etc. So we're not going to stand in the way of obstruct the benefits available for powerful searching or creating summaries or chronologies. And so to that extent, I anticipate that I will create a qualification to current paragraph 9 of the practice note, but spelling out the particular safeguards that will be expected and required. I have one entity submitted some suggested drafting along those lines, but I'm certainly open to receiving via my hardworking researcher Meg any other potential drafting suggestions. That was the issue which kept recurring in terms of the inquiries, and I'm sympathetic to that, but I'm also taking this opportunity to explain where the concerns lie. So at a minimum, there must be a controlled digital environment where the data is quarantined for use only in the proceedings for which it was provided. The data must not be used for training or developing the large language model, must be available only to those practitioners working on the particular matter, must fully respect confidentiality, and there must be meaningful assurances from Gen AI providers about privacy and data security and settings. Now, even if, as I would expect, such a carve-out is introduced, I can't emphasise enough the need for the profession to redouble its commitment to abide by its professional responsibilities in relation to the accuracy and integrity of information and evidence provided to the court, and also to emphasise the importance of the independence of thought brought to submissions and presentation of cases. And I'd also add this, at the deepest philosophical level, the rule of law depends on faith in the system, that there are responsible practitioners and judges bringing their own human minds to the administration and disposition of justice. There is a potential slippery slope with Gen AI, and I'm not a dinosaur. I don't think of myself as a dinosaur, but I am cautious and conservative about this. But the element of the human being in the administration of justice is a very fundamental, very, very fundamental consideration, and that's why I prefer to err on the conservative side, and why I have erred on the conservative side in formulating the practice note. So I'm very happy to take any questions from the audience and refer them to Justice Garling and Ms. Kanar. Are there any questions or comments? Yep.
In respect to the...
There's a microphone, yeah. Yep.
Okay, thank you. In respect to the application for leave to use generative AI in the preparation of expert reports, is it intended that application for leave would be brought after the expert report has been served, but
No, before
the expert report is prepared?
with the exception, there's a, so this is dealt with. So paragraph 20, subject to paragraph 23, Gen AI must not be used to draft or prepare the content of an expert report without prior leave of the court. The exceptions in those areas dealt with in paragraph 23, professional negligence claims and work injury management and workers' comp claims, where the expert report has to be served at the same time as the commencement of proceedings. That those two exceptions have different rationales, but in the workplace injury, the early provision of the expert report is for the purpose of facilitating settlement discussions prior to commencement of proceedings, etc. But otherwise, we wanted to escape expert reports prepared at great expense being presented as a fait accompli, but not having taken on board the protections or the really the protections and the disclosure of the use of generative AI. We'll see how we go. I mean, this is a classic area where we'll test it and we'll subject it to review. I don't know to what extent experts in different areas already rely on Gen AI and the production of content of their reports. No doubt in some areas, yes. I mean, one can imagine, for example, an expert wanting to subject 10 years worth of medical records to some interpretive Gen AI tool. Thinks of the, neurologists are often presented with years of medical records of people where their mental competence is in issue. For example, there may be engineering reports which involve very detailed technical calculations where there might be a desire to use generative AI, but if the use of generative AI masks the reasoning process or eliminates the reasoning process to come directly to the conclusion, that just on orthodox principles would not be received by a judge because it would be the classic ipse dixit, except the statement would be being made by the model rather than the expert, or the expert would be adopting. So people have to be able to test expert opinions, and the expert is required to expose his or her reasoning. That's the rationale for it. But as to whether we stay with the prior leave or not remains to be seen, but we're going to start with a prior leave requirement.
And sorry, just one follow-up question. Would that be done by way of an application, an oral application or a notice of motion?
It will be done at the stage where directions are given for the filing of reports. I would expect that each list will develop its own. It may be that we'll have a generic application form, or it may be that each list judge will adopt his or her practice as to whether it's done orally or not. But the practice note sets out the matters which need to be addressed. Would normally be able to be addressed pretty succinctly, I would have thought, ideally, probably from the court's point of view, in writing.
Thank you very much, Chief Justice. I just want to sort of, in considering the question about open and closed source programs, I think I just want to sort of raise also the particular challenges faced by unrepresented litigants in relation to the use of these generative AI programs. And I'm generalizing here, but certainly in my experience in the UK, they tend to use the more generic large language models and the more advanced bespoke programs that, if you've listened, paragraph 3, are more deployed, I think, in sort of law firms, larger law firms, although they are made more accessible now to smaller law firms. So I think there is certainly issues around sort of digital divide here. and certainly the space to watch is how the court could support unrepresented parties in relation to proceedings, but certainly the implications of this practice note for unrepresented litigants, even bringing this to their attention and then ensuring that they understand the details of the practice note.
Yeah, I've been very conscious, not just in terms of the digital divide, not just as between unrepresented and represented parties, but between affluent law firms and less affluent law firms, to develop a really sophisticated, high-powered proprietary platform, at least in the stage of the development of the technology, is a very expensive business. And some of the large firms went out very early and, as they're entitled to do, and invested a huge amount of money in technology and the development of programs, no doubt to get some early mover advantage, because, of course, these programs are of value not just in litigation, but in, for example, due diligence for corporate work and all other areas of work, drafting of legal documents, contractual documents, and the like. So there's, and those resources just aren't available necessarily to firms of a smaller size or less prosperous, or necessarily to public institutions, where there's often a lag in the making of money available for this. So I am conscious of that. But in a sense, some of those advantages already exist. I don't think we can regulate the use of that technology on an equity basis. I don't think our remit extends that far legitimately. But certainly judges will draw the attention of litigants in person to these guidelines. I hope they're clearly expressed. As I said, I think at the outset there may be some advantages for unrepresented litigants in terms of formulating arguments. It's important also not to generalise about unrepresented litigants. There are those who have obsessive personalities, and we have to deal with those. There are others who just simply are impecunious, but often actually have a good cause. And there's a difficulty in, sometimes, not always, sometimes there's a difficulty in articulating it. So one has to be careful about it. There are quite a few unrepresented litigants who've graced the bar tables of this court, who are highly intelligent and quite sophisticated in their approach. One of the there are people in the Supermax who are actually better advocates than many members of the bar, and get it right in terms of their legal argument. So one has to be careful about generalising there, but I think that's all I can say about that issue.
Mine is more a thank you so much for releasing the practice note. My company is actually the only company in the world that is developing an ethical and explainable AI model for law. So you helped me immensely to be able to explain, what is fit for purpose. So mine's just thank you.
Thank you. Any other questions?
Hi, I just have a question that happened to me recently where I emailed a client and they emailed me back and I thought everything was going well. And then she rang me and said, all of my emails have been written by Claude. And I was like, who's Claude? But Claude is one of the AI generative programs. And so my client had put all of her court case already into a public source thing and was just responding to me. And I didn't know without your practice note to be like, hey, we can't use AI. And so I had to bring her in and see what was going on. And I was wondering how we can tell the difference, because when I saw my client more in person, I could tell the reason that she used generative AI was because she has a hard time articulating what she wants to say. And so part of it was sort of like a assistive technology in terms of like assisting them actually say what they want to say. And it was actually quite useful in the meeting to do it that way in one sense. In the other sense, in this practice note, I don't know how, and we don't have any harm and principle issues because it was her information. So, but those sorts of, assistive uses that people might be using without us knowing about, would that person's affidavit, if I ever got to the point where I wrote it, be covered by the non-use of AI to generate the affidavit?
You would have to form a view about whether what he or she was telling you about the facts, if that was what was relevant for the affidavit, you would have to form a view about whether they were her instructions or his instructions. And
but I was just thinking, like, if it's been used, like when I ask what date did something happen and they ask Claude, what date did this happen? And then Claude brings back the date and I can check. It's just, anyway, I just thought I'd bring it up as something that might be happening further into the future that might start occurring.
I think lawyers need to be skeptical.
Yeah. I know. But I just wanted to know that we might not even notice if it's all by email.
Yeah. The example from the ACT, Justice Mossop had a character reference, and the language in which the reference was expressed didn't accord with his view of the witness in the witness box. And I used to, when I was at the bar, when I was cross-examining someone whose affidavit had some complex words, would often begin the cross-examination by asking them what particular words he'd used meant, and completely unable to explain. And that was a good start for cross-examination. But in Justice Mossop's case, it was the same, but he was able to pick it because it was a fairly clumsy use. It was a fairly clumsy, unsophisticated use of AI. And in a sense, similarly with submissions, because we didn't grow up on it and we sort of actually learnt the legislation and learnt the cases, etc., we can smell a rat, or we can pick up or detect illegitimate uses of it to present false information. The great worry, one of the great worries I have and other people have, is the more and more sophisticated it gets, the harder it will be to, in some areas at least, to detect fabrication. That is obviously, it's actually quite interesting for law reporting and authorised law reporting. And there's been a bit written about, forgotten the technical term, but the courts retaining absolute control over the authentic original decision, the original decision of the court. There was a recent case in England where an international arbitration award was wholly fabricated, and it got to the stage of an ex parte injunction, freezing a bank account in relation to a £70 million arbitral award. The whole thing was a fabrication. The award, etc., huge attempted fraud, but with very plausible looking court documents. So we have, that's the concern. Chair C.
I was just looking at paragraph 23, which is just up on the screen, which has the leave requirement where the expert has drawn upon Gen AI produced material. Does that mean that the expert has to have a pretty sophisticated understanding of any research that the expert may want to cite? Because I think it may well be that if the expert thinks that a research paper that it wants to cite in support of its opinions has been generated using AI, that it can't do that until, or the expert can't do that until we go and get leave.
It's a good question. It's not my expectation that an expert will need to interrogate every document to understand whether or not it was generated, but if the expert knows it was, he or she would be required to disclose it. Similarly, in the lay witness example, it may be that documents generated by AI have been used in a business or a transaction, etc. There's no problem with those being annexed if they existed at the time and weren't produced for the purposes of the litigation. But it's a good point, I think, about that, see whether that needs any clarification.
And I have a concern then about our ethical responsibilities, how much we need to interrogate the expert about what they understand generative AI to be.
Yeah.
Can I add a comment on that?
Yes, Justice
Can I
Carl.
just add a comment to that, Anthony? Experts have been used for many years to deciding what references are valuable and what aren't. And they do that by reference to well-known criteria. What's the journal in which something is published? Has it been broadly received within their profession? Has it been applied? And so on. As a matter of principle, I would have thought that most good experts who have been careful would have assessed the reliability of sources that they want to rely upon and whether they've been generated by AI, and if so, reliably so or not reliably so. So I think there's a crossover there that needs to be thought about. Sorry.
All right, we might draw it to a conclusion before anybody else thinks of a question. So can I thank you very much for your interest in attending. And we'll probably see you in about 3 or 4 months.